Hello, everyone, and welcome to the webcast. My name is Christine Dorsey Davis. I'm the Executive Director of the Ohio chapter of the American Planning Association, and I'm your webcast moderator. Today is Friday, September 4th. We will hear the presentation, The Peace Cross Case, U.S. Supreme Court and Local Guidance. For technical help during today's webcast, you can type your questions in the chat box found in the webcast toolbar to the right of your screen. And for your content questions related to the presentation, again, just type those in the chat box located in your GoToWebinar tool panel, and we will answer those at the end of the presentation during the Q&A. Coming up next on your screen is a list of our sponsoring APA chapters and divisions for 2020. Thanks to all of those participating and sponsoring and making these webcasts possible and free to members. Today's session in particular is a joint venture sponsored by the National Capital Area chapter and Maryland chapter of APA. So thank you to them for hosting today's session. Coming up next is a screenshot actually of our webcast webpage, ohioplanning.org/planningwebcast. This is where you can go and register for all of our upcoming sessions. And you'll see up at the top, there's a couple tabs. The prior webcast tabs, we do have some sessions available for on-demand viewing through the end of the year. I believe we have 2 ethics, a law, and a general session. So all those are available for on-demand, and you can get those credits that you need. The distance education tab, the prior webcast tab, that's where we post all of our PDF copies of our sessions. The distance education tab, that's where we post information on on-demand sessions. So be sure to check that out. And again, make sure you come over here if you want to register for any of our upcoming sessions. This is where you're going to do it. For those needing AICP credits, head over to planning.org, log into your MyAPA account. From there, you can either search by today's title or the event number that's there on your screen. This session has been approved for 1.5 CM Law credits. If you don't remember the title of the event number, all that information is found on our webcast webpage. So just head on over there for that. Like us on Facebook, just search Planning Webcast Series when you head over there. That's where we post any important information, like a new session that's available for you to register, or if there's a date or a time change, that's where we post that kind of information for you. And make sure you subscribe to our YouTube channel. We record all of our sessions and post them up on our YouTube channel. We have over 300 videos and over 3,000 subscribers. So make sure you join us and join all the fun. So that is the end of my housekeeping items. So from here, I am going to turn it over to Charles Kynes to kick off the presentation.
Great, Christine. Thank you very much. My name is Chuck Kynes. I am the president-elect of the Maryland chapter of the American Planning Association. I'm also a park planner with the Montgomery County Department of Parks, which is part of the Maryland National Capital Park and Planning Commission. Howard's going to get into this in a minute, but the MNCPPC is a bi-county agency just outside of DC that includes both Montgomery and Prince George's, and I work for the Montgomery County side. And both speakers today are on the Prince George's County side. So anyway, I am going to be moderating today's session. I'm now going to hand it over to Howard. I'm going to run the PowerPoint, and you'll see me again for the Q&A.
Thank you, Chuck. Very happy to be here. Next slide, please.
If your first slide is stuck, this is a trick and a tip for everyone on the call. Right-click your mouse and click Next, and then you should be good to go after that. And we can't hear you if you're talking to us, because I think you muted yourself.
Yeah, the only thing I'm seeing on the screen is Howard and me. The PowerPoint.
Oh, we see your screen. We see your PowerPoint.
Yeah, it's slide 1.
Here, let me take the controls back and then give them back to you again. This is what, you know, we can practice and practice. Hold on one second. I'll take it back. And then I'm going to hand it back to you again. Okay, let's see what you got. Can you see it now? All right.
Okay, it looks like we're good to go. I'm Howard Berger. I'm the supervisor of the Historic Preservation Section in the Prince George's County Planning Department, which is one of the compartments, if you will, of the Maryland National Capital Park and Planning Commission. As Chuck alluded, it is a bi-county agency that provides both planning and parks and recreation services in both Prince George's County and Montgomery County, Maryland. Very much along the same lines from one county to the other, but with slight variations based on certain responsibilities. In the context of Prince George's County, the Maryland National Capital Park and Planning Commission serves as the county's planning department, and within the planning department we have all the functional aspects that a typical planning department would have, including a historic preservation section, which is focused not only on serving as a technical service for the Prince George's County Planning Board, but we are also, the same staff has a second hat, which is the technical staff for the county-appointed Historic Preservation Commission, which regulates historic sites and resources through a local historic preservation ordinance. And as far as Prince George's County is concerned, the subject of today's talk is a piece of property that is controlled by the county's Department of Parks and Recreation. They have the publicly held portfolio of historic sites and resources and other recreational features as their mandate. The planning department is literally just a regulatory authority, and we of course liaise with each other regularly about common interests. I think thank you. The next slide. It just gives you a little background history about the Park and Planning Commission. We are in our 93rd year of providing planning and parks and recreation services to the two counties that are adjacent to the District of Columbia, for people who are not part of the local audience. Next slide. Another advancing. Okay, a little bit more about us, and of course you're not really here to talk about us, so we'll just proceed apace. My job today is to give you a brief history of the Peace Cross and to describe its historic and architectural significance, which of course will come to bear later in Bill's rather extensive presentation, but I'm just going to set it up for you in terms of what the Peace Cross actually is. For those of you who are not local, this map indicates in the little black rectangular box the approximate location of the Peace Cross nearby, but within about a mile of the District of Columbia border. You can see on the inset that the Peace Cross itself is set within a ribbon of roads and is in a very prominent location within the town of Bladensburg, Maryland, which is again within a mile of the eastern border of the District of Columbia. Bladensburg is a mid-18th century tobacco port established about 1742. So it is one of the county's older communities and the site of the infamous Battle of Bladensburg during the War of 1812, in which the British trounced the American forces. And of course, the community does have other areas of significance, but we'll just focus today on the Peace Cross. Next slide. The Peace Cross is a monument to the residents of Prince George's County who made the ultimate sacrifice during the prosecution of World War I. And you can see a relatively recent image of the Peace Cross in the middle of that ribbon of roads. And you'll see some historic photographs later to give you a little bit of its context. But I just wanted to give you some sense of its character. Next slide. Okay, this is on the right, you see a photograph of the Peace Cross while it was under construction. The effort to construct this monument began very close to the end of World War I in 1919 by a local VFW post. And that activity culminated with the completion of the Peace Cross in 1925. It is, as the slide indicates, a 40-foot masonry monument in the form of a Celtic cross. You can see in this photograph, prior to the skin of the monument being applied, that it is poured in place concrete with a hollow core and iron rebar supporting this concrete structure, and we'll talk about that a little bit later in greater detail. But the point of the monument is to embody the shared perception of the noble character and the valor of the veterans who made that ultimate sacrifice during World War I. And the VFW, local VFW hall spearheaded this work, at least for its initial couple of years. Next slide. And they were able to be functional with regard to this effort to construct this memorial only for a couple of years, and they needed to bow out by 1922, and they found another entity to take it over, which was another local American Legion post, which was active in the pursuit of not only finishing the monument, but sort of maintaining the ground from 1922 until 1956. After that point, the local American Legion post ran out of steam, and because of the nature of the location, you can see here in the sort of ribbon of highways that are illustrated above, that this is a very busy intersection and has historically been a busy intersection, and certainly by the post-World War II years, it was quite a location to have to manage by a bunch of volunteers from the American Legion. So to that end, they managed to transfer the ownership and the responsibility for the monument to the state of Maryland, which maintained it for a very short period of time, from 1956 to 1960, when the state of Maryland then deeded it to the Maryland National Capital Park and Planning Commission, and we are still the owner today. So we have been responsible for the maintenance of the little park that surrounds the monument, as well as the other monuments that have been erected subsequently since 1960. Next. Just to talk about the monument itself a little bit, there is a commemorative plaque that includes the names of all 49 of the men who lost their lives in World War I. The example on the left shows you a tombstone associated with one of those individuals. And when this matter suddenly became litigious a number of years ago, historic preservation staff mounted a research effort to try to learn as much as we could about the monument. And to that end, we began looking into the lives of the 49 men. Next slide. Thank you. Here you see a registration card for one of those men, describing his date of birth, his general characteristics, and so forth. He happens to have been a farmer who worked for his father in a rural area of southern Prince George's County, and we've managed to suss out all the records for these individuals and learned a lot more about them. Next. The point that I'd like to make here is that these men are buried all over the world. This is not a cemetery. This is essentially a cenotaph and a memorial to these men. Some of them are buried at Arlington National Cemetery. Others are buried at local family or church cemeteries in the area. And some are buried in military cemeteries overseas in the theater of war. We've been able to determine that through research that all of the 49 gentlemen were identified as Christian of one form or another, Christianity as adherents, and that at least 11 of the men are identified as African American, which is something that I don't think is a widely known fact. The other point I want to make here, which is just incidental, is that we're completely unaware of whether or not there were any women, for example, nurses, who might have been serving in the war effort from Prince George's County, and to the extent that any of them may have perished in their efforts. This monument does not address that issue. Next, please. Okay, here we have some photographs. Some of them are harder to see than others, but you get a general character of the vicinity in approximately 1930, after a couple of years after the monument was completed. A lot of the road network that exists today was in much more basic form 80 or 90 years ago, and you can see some of these roadways under construction. On the upper left, the monument is actually completed, and it's at the very, very back of that photograph. But here you see a couple of closer views. The one on the bottom probably from the mid-1930s, and the one on the upper right from a few years before that. This is looking from the District of Columbia toward the monument to the east. Next. The monument has architectural significance in addition to its commemorative value, and I want to talk for a minute about the person who's responsible for the design and construction of the monument. The monument is the work of a man named John Joseph Early. You see his dates there on the slide. He was a local architect and contractor who was responsible for a very innovative process of combining cast-in-place concrete with decorative concrete aggregates that were exposed for decorative purposes. And he developed these technologies, and there are many, many examples of his work in the Washington area or the Mid-Atlantic states, certainly, but he did have something of a national reach. And this is a relatively early example of his work, and I'll show you a couple of other slides shortly. So why don't we advance, and you'll get to look at some of the other work to put some context to this memorial. Okay, these are all, well, on the left-hand side of the slide are local Washington, D.C. examples. On the upper left is an example of what's known as a polychrome house. These were 4 speculative dwellings built in Silver Spring in the 1930s. They didn't really take off, and so there are only these 4. But you get a sense of how this decorative concrete technology was applied in a relatively modest residential context. In the lower left, you see Meridian Hill Park, which cascades down 16th Street in the District of Columbia, which is all of John Early's work. All of these feature his exposed aggregate. Next to that is a Franciscan monastery in Northeast Washington. And then the large photograph on the right is the Baha'i Temple in Wilmette, Illinois, outside of Chicago. So he did have something of a reach in his career, and is a person of note. Next slide. Okay, here are a couple of more examples. These are commercial buildings in downtown Washington. You can see the decorative effect that this technology was put to by Mr. Early in a couple of examples. And then on the right, larger photograph is an interior photo of the Shrine of the Immaculate Conception in Northeast Washington, to give you some sense of the variety that this technology can be put to. Next. Okay, from a historic preservation perspective, there are 2 things to keep in mind. Obviously, everyone has recognized the Peace Cross as a significant feature in the county since its construction, but formal actions were taken to recognize the fees for the property on these 2 occasions. The property was included in the most recent Historic Sites and Districts Plan as a historic site in 2010, and then a few years later, the monument was actually listed in the National Register of Historic Places in 2015. So that's sort of the framework that we're dealing with. And I'm going to close out my portion of the presentation by jumping ahead and just showing you what we're sort of dealing with at this point. You'll hear about the legal issues in a moment, but here are some of the physical and architectural issues that we're dealing with. Next slide, please. And then the next one. Okay. Park and Planning is the owner of this property and is responsible for it, its maintenance, and you can see some relatively recent photographs of some of the condition issues that the monument now displays. You can see cracking of the decorative aggregate surface. You can see some spalling from some of that surface. And in the upper right-hand corner, you see the very top of the monument, and you can see that those cracks are aggressive. And at some point in the relatively near future, we're probably looking at some fairly catastrophic failure of the decorative surface. So we are now in a position of having to address this from a technological point of view, from a preservation point of view, and we are currently studying the monument using consultants to do that because this is a unique technology, and there are only a number of people out there who are capable of effectively dealing with it so that we don't end up destroying the thing that we are trying to preserve. So with that, in 2020, I will turn my part of the presentation over to Bill Dickerson, and he will deal with the legal matters that have been attached to this property in the last couple of years.
Thanks, Howard. I'm Bill Dickerson. I'm principal counsel for the litigation team at the Maryland National Capital Park and Planning Commission. We represent the commission as a whole in both counties, but our office is actually at the Bi-County headquarters, which is only a few miles from the site of the Peace Cross. So this was an interesting, it just added to the interest level. I lead a team with 4 other attorneys, one of them Tracy Harvin, all of which work from time to time on it, but Tracy Harvin was extensively involved in the litigation. We handled the litigation from its inception through the Fourth Circuit, and then at that point, we, I'll just go into it now, but at the Supreme Court, it's become a highly specialized environment, and only a small set of lawyers regularly argue at the Supreme Court. And we were able to attract pro bono expertise to actually handle the oral argument at the Supreme Court. And of course, we participated with all of the briefing and all of that. But so we were involved in the entire process. But that was our role, was basically from inception to conclusion. And we go to the next slide. Okay, just a few as a lawyer. I am a lawyer who represents my client, so I have to make a few disclaimers. First, the presentation is for general education purposes only. It's not legal advice, can't be construed as legal advice. The opinions expressed are my own and not necessarily the position of my employer. I mean, as a lawyer, I have to consult with my client to ascertain their position that I'm representing on any particular issue. And responding today, I'm not really going to be able to do that other than what's already been in the record. So if we could go to the next slide. Next. Okay, here is a link to the Supreme Court decision. Again, I'm going to walk you through the process that got to that point. So next. Okay, so this case, the litigation started when suit was filed, but prior to that, there was a letter sent to the commission that the general counsel, my boss, responded to, asking us to take action to remove the monument because they didn't believe it should be on public land. And the general counsel wrote an extensive response at that point, basically outlining the legal authorities and why we believe that why the commission believed that the maintenance of the monument by the commission was constitutional. The American Humanist Association and 3 individual plaintiffs disagreed, and they filed suit claiming that the maintenance of the World War I memorial in the shape of a cross on public land violated the Establishment Clause contained in the First Amendment to the United States Constitution. Now, they sought 3 different types of remedies associated with it. One was that it be removed and taken somewhere else. And I think, as you can see from some of the other slides that Howard presented, moving the cross would be a precarious enterprise. Another was demolition of it. And another was what I believe the court referred to as amputation of the arms of the monument. Next, please. Okay, the Establishment Clause of the U.S. Constitution provides Congress shall make no law respecting an establishment of religion. Now, in the Bill of Rights, many of the provisions of the Bill of Rights have been what's called incorporated as applicable against the states via the 14th Amendment to the U.S. Constitution, the Due Process Equal Protection Clause. And in 1947, this particular provision, the Establishment Clause, was incorporated to apply against the states. Next, please. Okay, this litigation is what is referred to as kind of a subcategory of Establishment Clause cases as passive monument cases. Basically, there's a monument that's been there. There's no actual active governmental activity going on an ongoing basis. It's simply a passive monument. And under the Establishment Clause, traditionally in the development of the case law, it's been a very fact-intensive inquiry, and context is key to that inquiry. So history and purpose and use and the effect of it, and how a reasonable observer would perceive it have been things that courts have analyzed in these cases. And I will say one more thing about reasonable observer. It's what we refer to in our office, the existing law, which changes as we move on here. But the existing law was that the reasonable observer is what we would refer to as a reasonable docent, because the reasonable observer is assumed legally to basically know all of the relevant contextual facts, regardless of how they actually encountered the monument. Next slide, please. The lawsuit was filed in the U.S. District Court for the District of Maryland in the Southern Division in Greenbelt, Maryland, which is approximately 6.3 miles from the site of the Peace Cross. Now, there are two divisions in Maryland, so you can imagine a lot of times these federal divisions encompass great expanses of land, sometimes hundreds of miles. And this happened to be something that was very close to where the judges sit, was in the area. And again, it was only a few miles from our actual headquarters, and we're a few miles from the court. Thanks. Next slide, please. Okay, at that level, the American Legion had finished building the monument, and as you saw in Howard's presentation, they'd been conducting ceremonies for quite some time, and it served the caretaking function for it. And they had reserved certain rights to have ceremonies in the future, and there are also other rights not relevant at the moment. But on that basis, the American Legion moved to intervene, and they were granted leave to intervene based upon their interest in the case. So they became a party on the same side of the equation as the commissioner, although a separate party. And the American Legion has, this is not the first war memorial that the American Legion has defended from attack, and they had counsel and, basically an interest group counsel, as well as a large law firm as local counsel who were sophisticated in these matters. And that'll be important. I'll say why that's important in a moment. Discovery proceeded during the case, which was an opportunity to get historical records and information, and it was also an opportunity to take depositions. And I'll go into more detail that later on if time permits. But let's move to the next slide right now. We had a number of resources. Now, all sorts of governments that are confronted with this, they vary in size. You could have very small municipalities. You could have, larger counties, smaller counties. Our agency is actually, has been described, a pretty good size agency, and we were fortunate to have a lot of expertise that we could bring to bear that we didn't have to go out of pocket for with government expenditures. Like we had Howard and two other excellent history experts that assisted us with this case, and just brought in valuable expertise and information to it. Also in these cases, public affairs is key, and we had a robust public affairs section and very capable people. And in public affairs, because in cases like this, there tends to be a lot of public interest. There is a lot of public interest here. So there are responses to the community and to inquiries. And it's very important to have discipline in that, because you don't want to, because everything that any representative of the agency says in a litigation context is going to be under the microscope, and the other side will attempt to marshal it and use it. So good public affairs is very important. Our legal team, which I referred to in-house, we did have a strong litigation team in-house. Not every government agency has that. So we were actually well prepared for this. We also had the unique circumstance of having another party who had the same interest in the monument being declared constitutional. And oftentimes you will have interest group law firms approach governments to defend these cases and offer to defend it on their behalf. But that can become very problematic because their objectives may not be in sync with the government's objectives. And, and there are all sorts of collateral considerations associated with it. Here, we actually had very capable folks moving in the same general direction towards affirmance, maybe not in exactly the same way that was our agency's mission or approach, but it was there certainly was an efficiency and a gain associated with that circumstance of there being another party representing their interests, but moving in the same direction generally. And when we got to the Supreme Court levels, I think I started to mention we're fortunate to have very capable, experienced Supreme Court counsel unique to that setting, who came along to assist us and also handle the oral argument at that level. Next slide, please. Okay, the district court granted summary judgment in favor of the commission and determined that the commission's ownership of the memorial was constitutional, regardless of whether the court analyzed it under either of two tests that were potentially applicable, that we'll talk about in a minute. But the summary judgment is a mechanism to dispose of a case prior to trial. And the basis for that is you cannot have any material facts, meaning outcome determinative facts, that are in dispute between the parties, and meaning that there is a conflict in actual admissible evidence. And then that it's clear based upon those facts that are uncontested, that set of facts that's uncontested, that one party is then entitled to prevail under the law. And so that was the context in which the district court ruled for us, which is commonplace in these types of cases, that although they were very fact intensive, they are ultimately legal interpretation test questions for the court ultimately. Next slide, please. Yeah, and just to talk about the challenge facing the district court is that Establishment Clause jurisprudence or case law has been very complex and not easy to interpret. And although it's very interesting, as the court said in their opinion, Judge Chasnow said an Establishment Clause jurisprudence or case law is, quote, a law professor's dream and a trial judge's nightmare, because it's very difficult to sort out, but it's very interesting to talk about. And then they also quoted a couple other opinions in Supreme Court cases. One is that there's no single mechanical formula that can accurately draw the constitutional line in these cases. And another that said the Establishment Clause jurisprudence is in shambles. Next, please. So there were two approaches that had been applied. I mean, one would be a multi-factor test. The other is really more of an approach. The first one is Lemon versus Kurtzman. And this has been applied throughout Establishment Clause cases broadly. To pass that test, the government conduct must be driven in part by a secular purpose, have the primary effect that neither advances nor inhibits religion, and we'll hear more about effects later on, and not excessively entangle church and state. Then a more recent case dealing with passive monuments was Van Orden versus Perry, another Supreme Court case. And they determined, kind of foreshadowing where we ended up here, that the analysis in these cases would be driven by the nature of the monument and by our nation's history. In Van Orden, there was also a monument that had been there for a very long period of time, and other monuments surrounded it. Next slide, please. So again, we were talking about context is key. So what are the contextualizing elements of the monument? Well, one, you have the cross symbol's connection to overseas cemeteries in World War I. There's the reference to, there's the well-known World War I poem in Flanders Field about the crosses row by row. And there was actually an expert posited by the American Legion, who was a World War I expert, who testified about the connection. During that same era, the cross was adopted in certain military medals, like the Distinguished Service Cross and the Navy crosses, so there was association with that particular conflict. The American Legion, as you look at the pictures that Howard has, you can see that the American Legion symbol is at the absolute center of the monument. And again, as he described, the plaques with the 49 Prince Georgians names, and the terms valor, endurance, courage, and devotion are inscribed on the sides of the monument, as well as a statement from, or a quote from, President Wilson. Next, please. The location also is, contextualizes the monument. What we refer to as Veterans Memorial Park grew up around it. You have memorials to 9/11, which I believe is the most recent one, to the Vietnam and Korean conflicts, World War II, and a separate one for Pearl Harbor to memorialize that. There's also a large monument because, as Howard mentioned, this is actually in the site of Bladensburg, where the Battle of Bladensburg occurred. And so you have a very large monument, which is not far at all from the Peace Cross. You actually have a park that the commission owns, then you have a parking lot, and then you have this War of 1812 monument regarding the Battle of Bladensburg. And then a little further up behind the Peace Cross, you have two opposing soldiers, one British and one American, from the War of 1812. They were 38 feet high. And one of the issues in this case that was emphasized by the plaintiffs was that they thought that the size of the monument and being in the shape of a cross, that kind of should predominate the entire discussion. The monument is also a determinus of the National Defense Highway, which runs from there to Annapolis. Next, please. So then there's the use of the monument. What use was made of the monument? Well, patriotic events honoring veterans put on by the American Legion and other local organizations on Veterans Day, Memorial Day, Independence Day. It also is, you will see, the National Park Service has regional maps of historic sites, and one of them is for the Star Spangled Banner Trail, and the Peace Cross is a site on the Star Spangled Banner Trail. And as Howard indicated, it's on the National Register. Next, please. Okay, why did the commission own it? Well, if you can imagine, early on, there was not a lot of automotive traffic by the monument. Over time, that greatly expanded, and it got to a point where the state became involved, and then the state conveyed it to the commission, and of course, which makes sense that you would have to have a governmental agency to deal with it from the traffic safety standpoint. It would be sensible. Not that you would have to, but it would be sensible. And also because of the commission's role and charge statutorily, historic preservation is one of its important roles and functions, and we're well suited to handle that and handle the complexity of that faithfully. Now the commission, again, this is here where you look at two different things. This is where the commission's perspective or the commission's emphasis may have diverged a little bit from the American Legion's emphasis, who is dealing with cases, all sorts of monuments, not just ours. The commission's only interest was that the constitutionality of the monument and its caretaking of that monument be affirmed constitutionally, and it was. The commission was not interested in advancing a particular type of development of the law. Okay, next, please. So in the Fourth Circuit, the U.S. Court of Appeals for the Fourth Circuit in Richmond, the AHA and the individuals involved appealed the decision. The Fourth Circuit, like all federal appellate courts, sits in panels of 3. There are actually 15 judges, or there were at that time in the circuit, but 3 of them sit for each case. So you get a draw of 3 particular judges, and then you have briefing and oral argument. The court, that panel, ruled 2-1 in favor of the AHA and the individuals. The one who dissented on that panel and would have ruled in our favor was Chief Judge Gregory. So then there is, as is not unusual, there's a request for the whole judge, 15 judges, to rehear the case in what is called en banc, if you ever heard en banc. That just means all the judges would then rehear it. And it was rejected by a slim majority. 8 judges voted not to hear it. And as you can imagine, there can be all sorts of reasons. This is a discretionary situation for whether you hear the case or not, rather than even just the outcome of the case. So there can be a lot of reasons why a judge would vote to hear it or not to hear it. But they voted by a slight majority not to hear it. And then, of course, you see a link to the Fourth Circuit's opinion. Next, please. Okay, the U.S. Supreme Court was the next stop. Again, we had some great assistance at the Supreme Court level from very experienced Supreme Court advocates, and we filed a petition for certiorari and for writ of certiorari, and the American Legion did also. It's important to note that the U.S. Supreme Court is not what we would refer to as an error correction court. It's not like a court where you would, in most state systems, if you appeal to the first level, or even in the federal system, here is what happened in the Fourth Circuit. If you appeal to the first level, they have to hear your appeal, and they have to rule up or down on it. But at the U.S. Supreme Court, it's not an error correction court. They're interested in the development of the law. So there was a petition that's in there. They take a small percentage of cases, and it is completely discretionary. And we were fortunate that they accepted our case. And of course, that stayed the imposition of the Fourth Circuit's decision. Next, please. So in a ruling of 7-2, the Supreme Court reversed the judgment of the Fourth Circuit, ruled in the Commission's favor. And here's one of the paragraphs that summed up the ruling. The cross is undoubtedly a Christian symbol, but that fact should not blind us to everything else that the Bladensburg cross has come to represent. For some, that monument is a symbolic resting place for ancestors who never returned home. For others, it is a place for the community to gather and honor all veterans and their sacrifices for our nation. For others still, it is a historical landmark. For many of these people, destroying or defacing the cross that has stood undisturbed for nearly a century would not be neutral and would not further the ideals of respect and tolerance embodied in the First Amendment. For all these reasons, the cross does not offend the Constitution. Next, please. So there's a number of key points from the controlling opinion. It's a very these opinions are very long, and there are a multitude, there are multiple opinions, but which I'll get into. But there are several key points. One principle that you could expect to see in other cases is that the passage of time means that definitive evidence on original intent or motivation of design may be unavailable. You can imagine, although we had great historical experts who were able to derive records, it's still, when you're about 90 years out, it's very difficult to determine precisely what the motivations were in the design. I mean, the evidence is, to say that it's stale, there were even references to newspaper articles and events that, you know, were completely unverifiable. But that was the type of evidence people were struggling to try to marshal to support a position. Regardless of the original purposes for erecting the monument, a community may wish to have government preserve it for different reasons. So even if the purposes were potentially problematic, with the long passage of time, there may be other reasons to preserve it, and perhaps the meaning has changed over time. The monument may have been altered in ways to change its meaning and provide new reasons for its preservation, similar to that. And next, please. And it can become, and this was, I think, certainly from my perspective, true of the Bladensburg Cross or Peace Cross, it can become an embedded feature in a community, and over time, removal not viewed as a neutral act. That certainly seemed to be most of the community's reaction to it. And another important point that would be considered by a court, by a future court, it was non-discriminatory. There's no evidence of deliberate, is what the information Howard went over. There's no evidence of deliberate exclusion of symbols related to death of the 49 Prince Georgians and design of a memorial or Maryland Commission to maintain it. Although the plaintiffs tried to argue that, there really wasn't any evidence of it, and and they even tried to, and which was offensive to our agency, tried to tie it to some argument of racism, when I don't want to characterize our agency, so I'll just withdraw from that. But the tried to tie it to racism in the Ku Klux Klan, and the courts soundly rejected that nexus. And as Howard indicated, there were 11 African Americans whose names appeared on there, on the memorial itself, whose service was honored. Next, please. Some other key points from the controlling opinion. Destroying or defacing the cross would not be neutral and would not respect the ideals of respect and tolerance embodied in the First Amendment, and be seen by many as a hostility toward religion that has no place in our Establishment Clause traditions. The religion clauses of the Constitution aim to foster a society in which people of all beliefs can live together harmoniously, and the presence of the Bladensburg Cross on the land where it has stood for many years is fully consistent with that aim. Next, please. So the judgment was ultimately 7-2 in favor of the commission. The justices voting in favor of the commission's position were Chief Justice Roberts, Justice Alito, who wrote the controlling opinion, Justice Breyer, Justice Gorsuch, Justice Kagan, Justice Kavanaugh, and Justice Thomas. Justices Ginsburg and Sotomayor dissented from the judgment. Next, please. So there were 7 different opinions, and you can see Justice Thomas wrote a concurring opinion where he didn't believe that there should have been an incorporation of the Establishment Clause against the states in the first place, and that Lemon shouldn't apply in any circumstance. Justices Thomas and Gorsuch also said that really offended observers, quote unquote, shouldn't be permitted to sue or shouldn't be standing for that, when basically the nexus to jurisdiction here was for the constitutional claim was that people were offended by having to see it when they drove past it, and these would be, as I mentioned before, reasonable observers. That was part of the Lemon standard, and they would not say that that is a significant enough injury to maintain a federal action under the Constitution. Justice Kagan wrote a concurrence, and she would keep for analyzing these cases, the purpose and effects components of which I think would include the reasonable observer standard, out of Lemon and apply that to these cases, but she concurred in the judgment and believed that this particular monument was constitutional. Justices in Breyer and Kagan and their concurrence also indicated that they thought that newer monuments would be treated differently than ones that had stood for a long time, for the reason this case was all about history, and for the reason, when you have long history, it puts it in a different context. Justice Kavanaugh advanced something that would be referred to as the coercion test, and again, Justice Ginsburg and Sotomayor would have found the maintenance of the cross unconstitutional. Next, please. Okay, so what is the practical impact on the law? I think we talked about that a little bit, but that it would really be this test that looked to the history and the traditions of the country, and that it would, and the fact that particularly when a monument has stood for a long period of time, that there would be a presumption of constitutionality, and that you would take into account that the meaning could change over time, its context could create meaning, that and also you would look at whether an important factor would be if there was actual discrimination involved in the design and the implementation of the monument. If there was basically a discriminatory impact, that would probably be a factor that would impact the analysis significantly. Then a couple cases that have arisen since that have cited to American Humanist Association versus American Legion of the Commission, Woodring versus Jackson County, Indiana, which basically that case, they concluded that a plurality of the Supreme Court held that the Lemon test was ill-suited to resolve Establishment Clause cases that involved the use for ceremonial, celebratory, or commemorative purposes of words of symbols with religious associations. Then there was a case that was actually in the pipeline at the same time, although just a little bit later than ours, the city of Pensacola, Florida, where the city, I believe it was, had filed a cert petition with the Supreme Court. But that case, it was reconsidered by the 11th Circuit in light of the decision here. Next, please. Okay, before we get to questions and answers, I'll just take a few moments and highlight a few other issues. I said that if I had time, I would talk a little bit about the discovery phase. In the discovery phase, one thing that was interesting is you have what's called a Rule 30b-6 deposition in federal court. You have a counterpart to that in most state courts as well, which means you can't really take the deposition of an organization. So, but you have the opportunity to secure answers that are binding, the questions that are binding on the organization. And the way you do that is something called a 30b-6 deposition. And the proponent of that deposition, when it wants to take it, is required to designate certain areas of testimony for the deponents to give it. So that you have to, as a government agency or as any organization, you have to designate people who can speak to particular issues and prepare to speak to particular issues on behalf of the organization. And that occurred here. We had to designate, I believe, 4 people in different areas of specialty to speak to different issues that were raised in the 30b-6 deposition notice. And one of them was one of the deponents who actually has a history background and actually a legal background and a planning background. I believe is a member of APA. He was sitting for a deposition. He had a fairly narrow designation, but plaintiff's counsel wanted to go on a fishing expedition and had a stack of photos of monuments and wanted to hypothetically ask him whether the commission would accept this monument or not. And of course, and a lot of them were religiously oriented. And of course, this one was a cross, so it was a Christian nexus. And there were nexuses to other religions. And there was even one that was a statue of Satan that has been, it's what it was called. And they wanted to ask questions to basically play a hypothetical game to say that, oh, well, you would discriminate against us as the commission, or you would agree to it and we would find a place to put it. I mean, presumably is where they were headed. I objected to it both as being outside the scope of the deposition notice. It wasn't what this witness was designated for, and also not relevant to the case because it was hypothetical and we were dealing with one particular monument that had its own particular history and context. Ultimately, the lawyer talked about going to the court to see if he could get the judge to compel him to answer the questions, but then they ended up backing off and it didn't happen. But apparently this is a fairly common tactic that occurs to try to bring new monuments to an area. So that's something that we need, I think, as government folks to be mindful of that's out there. And related to that is the issue of, and exactly related to that is the issue of opening forums. Like if a government permits certain activities in a certain space, and that could be planting monuments, or it could be, events or activities. Once the forum is open to the public in that manner, you can have, the access to it has to be content neutral. And so that's something to keep in mind. And although you could employ reasonable time, place, and manner restrictions, you need to understand that the government needs to understand that decision makers at the highest and politically accountable level need to understand that that can have consequences. Right now, there is a case that's pending in DC that's very topical, which is there was a painting on the roadway of Black Lives Matter that was allowed by the DC government, and a legal activist group known as Judicial Watch had asked that their motto be painted on another street. And apparently that was denied, and they filed suit, and so that suit's pending. But that's just kind of like a broad and topical illustration of once a forum is open, the access to that forum has to be content neutral, and you could end up with, I'm not saying a particular content, but you could end up with a totally different setting than had been planned. And maybe you wouldn't have done the first thing if you'd have known that you were going to have the rest of it come in its path. But that's just kind of a more global practice pointer. But it is, because as you see here, tying it back to the case, the court looks at what occurred at the monument site, and the court looks at the access that's provided to sites. And at this point, I think we could open it up to questions.
Great. Thank you, Bill. Just reading off, this is Chuck Kynes again, just reading off the question and answer, the questions in the dialogue box. One of the questions is, do you think this case will encourage various levels of government to erect new monuments with Christian symbolism?
I do not. And I say that because it's a very backward-looking decision. And there are two justices that very specifically said that new monuments would have an entirely different level of scrutiny. I would anticipate that the evidence would be entirely different. The evidence would be fresh, and the motives, and if those were motives that would be impermissible motives, if you look at the history and traditions and how it fits, I think there's a lot of language in the decision that would make a government, if they looked at it, circumspect about that. And I remember distinctly at oral argument at the Supreme Court, Justice Breyer, I think, questioning the lawyer for the AHA, saying, well, what about it? What about monuments? You know, this monument's been there for 90 years, I'm paraphrasing. What about these and no more? So I think that's the orientation of at least several members on the court. That it's different if it's a newer monument for a number of different reasons.
The next question is, was there any internal disagreement within the organization about whether you should defend the monument or not?
That would be within the realm of attorney-client privilege. I couldn't really speak to that. I would say you'd have to just view us by our actions, but there was obviously, we have a very forward-thinking agency that is sensitive to community always and sensitive to issues. So you can imagine that they wouldn't have taken any different approach to this matter.
That's all I'm seeing in the dialogue box, unless Christine, you see other questions. So I'll throw in one final question or one additional question, and that is, for those of us, and most of the people on here, I would think, studied for the AICP exam, one of the issues that you have to study intensively is the Religious Land Use and Institutionalized Persons Act. So what effect, if any, did this case have on that federal law?
Well, I'm not an expert on that act. I have some familiarity with it, but claims under that act would be statutory-based claims rather than constitutional-based claims, although you could see a scenario where both could be, you could join claims of different types in a situation. So for that reason, and also for the fact that under RLUIPA, I think you're dealing with things that are happening in the here and now, actions that are going to be taken. Someone who is attempting, or a developer or other person who is attempting to take actions to develop land. And we're talking about land use restrictions. And it's all in the present. I think this case speaks to monuments that have been there for a considerable period of time and at its core. So I don't think it would have direct application to RLUIPA. That said, you never know what a court will borrow when they're analyzing issues such as whether something constitutes impermissible assistance to a religious organization, or whether it's being unfair to a religious organization, or analyzing whether, yes, this is appropriately neutral. So it could be borrowed for that purpose, theoretically, quite possibly.
Okay, we have another question, and that is, any impact regarding the more recent removal of statues perceived to be racist?
This case is limited to Establishment Clause and to religious discrimination in particular, so it doesn't really speak directly to that issue. It does, however, speak to one of the linchpins of this decision, I think, is that in the record, as we have kind of detailed, there was no discriminatory exclusion in the design and with regard to race, in regard to the design and of the monument. and listing. I mean, you could imagine that's not the case for all monuments, but I would say, one, this is an Establishment Clause case, so you would really need to be comparing it to another religious freedom issue or religious Establishment Clause issue, and as well, there isn't discrimination in this case, and although you do have the absence of discrimination as being a linchpin of the court's decision, so it was relevant, but I just don't think that there's really a strong analogy from this case to other monuments that are not raising Establishment Clause issues.
Okay, great. The next question I see is, what impact will this case have on the removal of Confederate War memorial statues erected during the Jim Crow era?
I don't think it has any direct relevance, because I view those as separate issues, not on the surface, they don't seem to raise Establishment Clause issues. It would seem that would be a different analogy, or a different analysis, rather.
Okay. The next question is, please clarify the ruling. Does it mean that the cross can stay, or that you are also free to restore and maintain it?
We believe it. We believe it means both.
Okay, great. The next question is, did the Trinity Lutheran decision come into play?
I would say no, because off the top of my head, I'm not familiar with the Trinity Lutheran decision. I don't recall that being an issue in this case.
Okay, great, thank you. Next,
is there any more gloss on Trinity Lutheran, or is that it? Any more explanation of?
There was no more explanation in the chat box. Maybe whoever submitted that question can submit additional information if you want him to elaborate. The next question is, wouldn't not allowing a structure, if the community wanted it, be discriminating against that religious community?
Okay, would not, I'm sorry, Mr. Kines,
I'll repeat it. Would not allowing a structure, hold on, I lost it. I have to go down, hold on, I lost it. Okay, here we go. Would not allowing a structure, if the community wanted it, be discriminating against the religious community?
I think this goes more towards the open forum question that I described, which is, okay, it may be that the government properly determines as a matter of planning and its land use and for the community that there will be no structures. But once you open it to structures, then you potentially open the door to someone claiming that a particular type of structure should be there along with the other structures and to have content neutral access. That would really, I think, be the issue. But it's very difficult to discuss that one in the abstract.
Okay, great. The next question is the temporary erection of religious symbols during holidays on public land, for example, a creche, C-R-E-C-H-E, or a menorah? And that's all it says.
I'll just comment on that by saying that there is extensive case law on seasonal religious displays that have been validated if they're inclusive, is my general that case law. That's
so I think she's saying She's asking if it's subject to the Establishment Clause.
Yes, there's a fair amount of case law on those under the Establishment Clause.
Okay, great. The next question I see is, was there discussion of transferring the property back to a private owner?
Let me put it this way. I can't get into anything that would be an attorney-client privilege discussion, but what I will say is that we did have various inquiries and offers to do that from third parties.
Okay.
A number of them.
Okay, great. The next question is, what would be the implication of that be? I guess that was a follow-up to that previous question.
Right. I understand the question. I don't want to comment on that one.
Okay. The next question I see is, do you believe that this ruling can have a positive effect on future cases of this type or similar? If so, how old would the feature have to be?
What I'll say is that that this case in a way is a validation of the importance of history, and that the court clearly is mindful of the historical context and would take that into account. And clearly it is how long something has stood and stood without objection, and how it is perceived in the community. All of those things would be highly relevant to an Establishment Clause challenge. That said, how many years? I think that would be case by case and fact by fact. I think these are still going to be highly factually, the factual context is still going to drive the decisions. And you can imagine you could go to the extremes, but I can't do any better than going to the extremes. I mean, other than 90 years ago is one thing, last week's another.
Okay, it seems like the original Trinity Lutheran question provided additional information, and that is Trinity Lutheran Church of Columbia versus Comer. The department had a policy of categorically disqualifying churches and other religious organizations from receiving grants under its playground resurfacing program. The question is presented is whether the department's policy violated the rights of Trinity Lutheran under the Free Exercise Clause of the First Amendment. 7-2 decision for Trinity Lutheran Church. Majority opinion, Justice Roberts, the exclusion of churches from an otherwise neutral and secular aid program violates the First Amendment's guarantee of free exercise of religion.
Yeah, I would say that's to answer that question now. That it's a very different case. It's a free exercise clause case rather than an Establishment Clause case. You're dealing with active governmental activities versus passive activities, passive monuments here. In fact, it serves to draw a good contrast that, and you would not know from this decision how those types of issues would be addressed. You'd be better to look to that case.
Okay, great. The next question I see is, can you discuss the experience of finding a firm to represent the commission at the Supreme Court, and also writing written arguments and making oral arguments before the court?
Okay. The process, we actually went out to oftentimes in government, obviously we had a short time frame on this. We did a solicitation we did research to identify the firms that regularly practice before the Supreme Court. And we did, in essence, a solicitation, and we did an inquiry if they were interested in making a proposal. And I believe we had multiple proposals from very well-known firms to handle the matter on a pro bono basis, because it is very, very attractive to argue before the Supreme Court. And I think that's the one aspect, and we actually, Hogan Lovells and was the law firm that we ended up having for the Supreme Court, and Neil Kotyal and Mitch Reich were the two lawyers from there that worked on the case. I'm sorry, what's the rest of the question? What was it like? I didn't actually argue at the Supreme Court, but I participated in the briefing and all of the, and there were moot courts that we would have. That's one thing that you would do to prepare at that level. You would a lot of lawyers get together and basically practice in what we would refer to as a moot court setting. It's very, I can tell you from having done a fair amount of appellate work, I'm used to more often, the Court of Appeals in our state has more members, but typically I'm dealing with 3 judge panels like I did when I argued at the Fourth Circuit. 9 is a lot more than 3, and you have, and I think the Supreme Court context is a lot different because of the types of cases that they handle. But the Fourth Circuit was, appellate work is always a very interesting experience. You've got to be really well prepared, particularly in a case as complex as this.
Okay, thank you. The next question is, as a follow-up to the open forum discussion, if a display is allowed, is a government then obligated to allow other displays, or would removing a display satisfy a legal challenge?
Okay. Here's what I'll say about this. This kind of goes back in part to the disclaimer earlier on, but also I kind of opened this line of discussion with a discussion on open forums. My intent with that is to sensitize people to the issue, and that there is an issue there. And frankly, these cases about, well, can you solve it by removing something, or do you have to allow other ones? Again, that's going to be a fact-specific endeavor, and my counsel would be to, basically provide all of the available information to the attorneys that you have access to, and seek capable legal advice for those issues, because they turn on specific facts, and they're all different.
Great.
I'm going to go back, if I could, sorry, Chuck, for a moment. And if you remember one of the early slides talking about the Establishment Clause, there was the one that the district court quoted in its opinion that basically said there is no bright line, a bright mechanical line to address all these cases. And so the factual context is always important.
Great. The next question is actually from our webinar organizer, who I forgot to acknowledge at the beginning of the webinar, and I apologize. Mark Lewis DeGrace is a officer on the National Capital Area chapter of APA, and he was the organizer of this webinar and pulled all the various parties together. So I wanted to acknowledge Mark. And his question is, I understand that your client displays, hold on. Your client has other displays, or would, hold on, let me start over. I lost it, hold on, let me go back. I understand that your client wanted to peruse this case and were pleased with the decision, but what are your thoughts on the dissenting opinions?
I would say that we disagreed with them, that respectfully, that we believed all along, and that's why we took the approach that we did, that the historical context of this monument passed constitutional muster, and that this is not another monument. This is not something that occurred more recently. This is not something that has other facts associated with it. This is something that in the language of the decision became embedded in the community. embedded in the community to the extent that if you've lived in that region, you would know that the Peace Cross is frequently given as an example in driving directions. I mean, that's how embedded in the community it is. It's a very well-known landmark, very important to the local residents as expressed by the communications that our public affairs people receive.
And the next question, I think, is also from Mark. Has the commission started identifying other monuments in Montgomery County and Prince George's County that may be challenged in the future? And since you won, does that mean that the other side has to pay for all your legal fees?
Okay, the first one I can't really answer. The second one, no. I mean, there is a risk that the government or the defendant in a case would have to pay the legal fees of the prevailing party who prevails under what in essence is a civil rights or constitutional claim. But it is not truly a two-way street. There is a provision that would enable a potential recovery of attorney's fees by the defense. However, the standard for that is not simply that you prevail. The standard on the defense side is much different. The standard on the defense side is not dissimilar from what we would, from what would be, I know I'm getting into a lot of technical detail here, but Federal Rule 11, which is that a bad faith claim or a claim that was filed without substantial justification or reasonable investigation. So it's a very high standard for defense to recover, whereas a prevailing plaintiff could recover as a matter of course.
Okay, Mark clarified that a question about the inventory in Montgomery and Prince George's was for Howard. So I'm not sure if Howard, can you jump on and answer the question about whether you've taken an inventory of other monuments in both counties that might be affected by this ruling?
Well, I'll give a cautious response. One, I don't know what Montgomery County is up to specifically. And two, any work that we would have done to identify monuments is not necessarily in the context of this ruling. It is to its own end. I mean, we have an active program of documenting historic and cultural resources, and we are essentially aware of all of those that currently exist. We haven't done anything in the specific reaction to this ruling.
Yeah, and I would say in Montgomery County, we have an extensive historic preservation staff and office, and we also have an extensive cultural resources program on parkland, and they coordinate pretty regularly. So I can find out and maybe find a way to share that information with the attendees. The next question is by email. Was it argued that the continued funding of a monument with religious connotations constitutes the government's active promotion of said religion?
I think that was at the core of the AHA's argument. And there are two components to it. One is if you were looking at under Lemon, does it advance religion? They were arguing that the effect was to advance religion. So I think that's kind of similar. A related note is the third prong. Again, I don't believe that Lemon necessarily, I mean, we have to look at the opinion on that, but the third prong was excessive entanglement under Lemon. And there really isn't, even in this scenario that is described, I don't think you would have a real entanglement with religion for that third prong either. And although the Fourth Circuit panel said it was an excessive entanglement, that was Frankly, that argument was soundly rejected at the district court and soundly rejected again at the U.S. Supreme Court. So I do think that that was in front of the court, that argument.
And it looks like the final question is, has the Maryland Historic Trust played any role in the ruling or preservation of the monument?
Howard, can you?
Well, I think the simple answer is no.
Okay.
I mean, it's park and planning property, and we are in the process of figuring out how to address the, condition issues that are present, and we have not relied on any technical assistance or any form of assistance from the Maryland Historical Trust to date for this project.
Okay, and another question just came in related. Did the State Highway Administration have any say in the effort, or either of the roads state highways, or any of the roads state highways?
And I'll defer again to Howard after saying that I'm not aware of their involvement in this particular case.
I'm not aware of it either, and I believe some of those roads are state controlled.
Another question just came in. When will the monument be restored?
Well, I think that comes under the heading of the $64,000 question times 100. We don't know the answer to that. We are in the process of determining what specifically an appropriate treatment plan would be, given the uniqueness of the technology here. And it'll be a multi-year effort, and we're still in the research phase. So it's anyone's guess. 4 years out at a minimum.
Okay, great.
I think
that's
wrap
it.
us up then. Thanks everyone, and thank you, Chuck, for moderating the Q&A today, and thanks everyone for joining today's webcast. A couple quick reminders for you. We are recording this webcast. It will be available on our YouTube channel. Just search Planning Webcast on YouTube and we'll pop up for you. And we will have a PDF version of this slide deck available on our webcast webpage, ohioplanning.org/planningwebcast. Thanks to the National Capital Area chapter and the Maryland chapter of APA for hosting today's session. And of course, to those that were involved, Mark and Bill and Howard and Chuck for joining us today and talking us through this. Don't forget to log those CM credits. They're the coveted 1.5 CM laws, so head on over and do that. And everyone have a great weekend, and we will talk next time. Thank you.